a trust with a national bank trustee to compliantly hold mortgages. And this goes on and off about being a hot topic. When we first started buying mortgages in larger volumes in 2013, I'll tell you, when I'll give you a brief history while we wait for others to log in. In 2010, we started buying defaulted mortgages at American Homeowner Preservation. We started a fund called American Homeowner Preservation Fund, which was, and all our assignments, everything said American Homeowner Preservation Fund LP. And that was it. And we did that. We bought hundreds of mortgages, maybe a couple of thousand into that entity in 2010, 11, 12, and into 13. We did realize that there was a compliance concern. So we, in 2013, we did establish a trust, American Homeowner Preservation Trust, and that is how we've held mortgages ever since. So we'll go, I'll repeat all of that, but just to kind of, as a prelude to what's to come. So my name is George Newberry, founder and CEO of AHP Servicing. I should be joined by our general counsel shortly, Christine Sayers. There we are, Christine, as if on cue. Good morning, good afternoon, Christine. Hi, welcome. All right, so we are, and I see we have our NMLS number on the home page, on the first page of the PowerPoint. So I imagine that's your influence, Christine. So I appreciate that. So welcome, Christine. Christine's our general counsel, and in fact, in preparation for this webinar, she's been reading up on some of the recent enforcement actions on for those mortgage holders who do not hold their loans in a compliant holding vehicle. So we will get started right now. Welcome, everybody. I see people still logging in, so that's good, but we will get started. So this is how to use a trust with a national bank trustee to compliantly hold mortgages. Okay, so state licensure. This webinar, who can this help? This will help you if you own mortgages, but are not currently licensed to hold mortgages in the approximately 20 states which require licensure. There are states which, about half the states in the union, require that you have a license to hold or enforce a mortgage, and so you either have the license or you operate under some exemption. So why is this sometimes a hot topic? It becomes a very hot topic when people get fined, and usually the fines come with orders to divest. And so a state, and the most recent ones that have been very aggressive with this are Pennsylvania and Georgia. Pennsylvania has been aggressively finding people pretty large, or mortgage holders fairly large amounts, as well as giving them 30 days to divest their Pennsylvania assets, so mortgages that are secured by properties in Pennsylvania. Georgia has, for a long time, has been very aggressive. Maybe a decade ago, they slapped Condor with a big fine. If I recall correctly, it was over $1 million for holding loans without a license. And these states, so there's approximately 20 states that require the license, but these are the two, Pennsylvania and Georgia, which have been aggressively enforcing this. Other states, Massachusetts, we've heard of enforcement actions, and Christine, you may have heard others here and there. But it has become a big problem in both Pennsylvania and Georgia, and in some respects, they're simply interpreting the law differently than others, and let me explain. So in Pennsylvania, AHP Servicing was actually, when we applied for a servicing license, they said, hey, we disclosed that we currently own mortgages in Pennsylvania, and we owned them in a trust, American Homeowner Preservation Trust, and that they were serviced by other third-party servicers. And as part of that disclosure, the state came back and said that we were that was unlicensed activity. So here, this is the problem that I think some of us have faced, and we've we've created a solution for ourselves, which we're hoping to share with all of you. but the states, at least Pennsylvania, is interpreting ownership of a mortgage, even if you don't service it, because many states you can say, hey, I own the mortgage, but I've retained this servicer who is licensed in the state to service the mortgage. As a result, I don't need a license. And in many states, that perception and that structure is acceptable. But Pennsylvania is saying that if you own a mortgage and you hire a licensed mortgage servicer, that's not enough. Because you own the mortgage and you own the rights to the servicing rights, basically allowing you to select who the servicer is, then you, as a mortgage holder, needs to be licensed, which means that you need a to obtain the license in the first place, and it's state-by-state licensing, and then maintaining that license, which is typically requires continuing education and other requirements. In some cases, there may be a surety bond and other requirements. Christine, I mean, you do this all day with the different states. You deal with the regulators. Any comments on what you've especially read up lately in terms of how Pennsylvania is approaching this?
Yeah, so it appears that Pennsylvania is approaching it that if you are not an originator and you hold a license to originate, you just acquire loans on the secondary market, that you're basically considered the master servicer, and any servicer that you hire to service those loans would be the sub-servicer, and a master servicer would have to be licensed or hold it into, you know, some type of trust vehicle, fall under some type of exemption, which would probably be a trust vehicle.
Yep. Yeah, the trust is not unique to AHP. During the subprime days 20 years ago, Wall Street's preferred vehicle for holding those mortgages was in a trust. And you'd see many a times, you know, US Bank as trustee for, Deutsche Bank as trustee for, Bank of America as trustee for, and then you'd have all these different trusts that were created to hold these subprime mortgages and other types of mortgages as well. But what happened in the foreclosure crisis is that many of these banks were targeted. Advocates, activists, families that were being foreclosed on were protesting the bank, even though many times the bank was simply the trustee, was not, you know, US Bank was the trustee, and in some cases they were not the actual mortgage holder, but they were the ones experiencing the reputational challenges that came with being the trustee. So as a result, some banks have exited the business. Others have become more difficult to more discerning in who they allow to who they work with in terms of trusts. But back to Pennsylvania. In Pennsylvania, when we applied for service to become a servicer and get a license there, they reviewed our operation. They said, hey, that you are your holding of these loans is deemed unlicensed activity under Pennsylvania's mortgage servicing licensing statute. Now, we went back to them with a 4-page letter, and we said that the trust, acting through its trustee, US Bank, is exempt from Pennsylvania's licensing requirements, that all servicing rights that were transferred from the trust to a separate duly licensed third-party servicer, as required by the trust agreement, and considering the beneficial owners of a trust, which were us as the ultimate mortgage, the beneficiary of the trust, and the ultimate beneficiaries of those mortgages held in the trust, as indirect services has no basis under the trust agreement and would have a significant implication in the mortgage industry. And as we went back and forth with Pennsylvania, they did relent and say that, okay, they agreed that we are exempt, so that we were not conducting unlicensed activity. But I will tell you that if we were several years prior to this was 2017, if we went back to 2012, we did own loans in American Homeowner Preservation Fund LP, without the benefit of a trust. And if we had applied to be a servicer and they examined that, that would have likely been considered unlicensed activity. And so be aware, that's the distinction. And we see a lot of enforcement lately, and I think it's causing a lot of challenges for especially smaller mortgage holders who maybe can't afford to set up a trust on their own. Georgia, similar, and Georgia's gone one step beyond. And not only are they finding the unlicensed mortgage holders, but they're filing those who sell to unlicensed mortgage holders. So AHP Servicing sold a loan. We discovered this because about a year and a half ago, we were in an audit, and as part of our audit, they said, hey, you originated a loan and you sold it to a hedge fund, and that hedge fund was not licensed. And so we're going to find the hedge fund, and we're going to find you. So that was problematic, and as a result, I think many of you may be seeing in, there's tapes that come out that say that to bid on assets in Georgia, you need to be licensed, a licensed entity, or or hold the loans in an exempt entity, because otherwise the sellers realize that they're at risk of getting fined. So that's and the explanation from the state is that if you're a seller of mortgages in Georgia, it's your responsibility to due diligence to make sure that whoever buys your loans is licensed, can properly compliantly hold those loans in Georgia. Enforcement action. So we've had funds and some smaller investment groups who've come to us and said that they've received an enforcement action, and there's two components to the enforcement actions that we typically see. Number one is a fine, and I'll tell you, some of these fines appear disproportionately large. It's somebody who had 8 loans, I think and mostly second mortgages, I think the fine was $50,000. So they are outsized. I guess it's all a matter of perspective, but they're not like, hey, you get fined $1,000. The fines can be quite big. And there's an order to divest. So the loans need to be sold or otherwise divested within a year. I'm sorry, within 30 days typically is what we've seen in these orders. So what has happened is some groups at this point where they're getting fined and they need to divest their assets, they've come to us and we have come up with a solution to put those loans into our trust, into American Homeowner Preservation Trust, and they retain all the economic benefits. They retain delegated authority to manage those assets, but they're simply held in the trust, and that makes it, which is an exempt vehicle, and creates a compliant holding vehicle. So regulators so far have been satisfied with that. Hey, we've sold the loans, here's the new holder, and then because it's held in a trust, everyone gets left alone. So here is that solution. So we established American Homeowner Preservation Trust in 2013. Since then, we've created 7 series of the trust. So each series is almost like its own trust, and they're insulated from one another. And so you'll see this over and over. If you've ever bought or sold a loan with our trust, you'll see that the mortgage assignment and the allonge will read U.S. Bank Trust, National Association, or NA, as trustee for American Homeowner Preservation Trust. In this case, it's Series AHP Servicing. And that is, when regulators kind of look, okay, compliant, not compliant, once they see a bank and a trust, in our experience, they consider that compliant, because it is. And just as we went back and forth with the state of Pennsylvania, in the end, they were comfortable with the structure. And it wasn't, again, not unique to us. This is being done, has been done for years, has been done by probably most or all of the major Wall Street investment banks who had investments in mortgages. It's just a structure that the preferred structure for compliance. So so if you said, okay, well, I have loans, if you have loans in Georgia and Pennsylvania and you're not holding them at trust and you're not licensed, you have those options. You can go ahead and get licensed, which is fairly easy. Actually, Christine, just so everyone knows that option, what would it take to get the necessary licensure in Pennsylvania and Georgia, and any other states, but we'll focus on those two, so somebody can hold these compliantly?
Yeah, so I would recommend that everybody go to NMLS Consumer Access. And I don't know if it'll let me put the link in the chat, George, but I could send that to everybody, and they can just click on each individual state and the guidelines as to what it costs for the license application, for any bond requirements. All that information is in there. There's a whole map of the United States. You just click on each state individually.
So that is definitely an option, and you could do it. It does require, it's not just, to be clear, Christine, it's not just fill out a form and pay a fee. It's typically fill out a form, pay a fee, identify, take some necessary course, education, and pass a test. Is that typically the case? Because assume that they don't already have MLO licenses or something like that.
It depends on the activity they're doing.
Okay, so they may or may not need to take education, and most of these licenses would need to be renewed on an annual basis.
Correct.
Okay, and if there's new bonds, you'd have to get another bond.
That's correct.
Got it. So that's helpful. So that's one option, definitely one that is worthwhile to explore. And I would guess say, if you're only buying in one state, and so there's enough volume, maybe it does make sense to do that. But the other route is to put the loans in our trust, an American Homeowner Preservation Trust. Basically, the loans go from your current entity, and I'll use our old entity. I'll use our old entity from 2012, American Homeowner Preservation Fund LP, would assign the loans into the trust. With U.S., you go back to this vesting, U.S. Bank Trust, National Association as trustee for American Homeowner Preservation Trust, Series AHP Servicing. So now the vested owner of those loans is the trust. Next is the allonges, same thing. They're all endorsed over to the trust. And now what do you get in return? So now you put these assets in, what do you get in return? You get delegated authority. We give you a participation agreement for one or all the assets. It's one agreement typically, and it will give you a delegated authority to manage. So you get to call all the shots in terms of what happens with these mortgages. If it's in foreclosure, what do we bid at the foreclosure sale? Once it's REO, do we sell it as is? Do we, if it's going to foreclosure sale, what do we bid? Do we fix it up and sell it, or do we hold it as is? Do we, all these things, because the loan is held in the trust. Once it goes REO, it's still held in the trust. And you also get all economic benefits. So any payments that come in each month, if there's a loan sale or an REO sale, this is like a regular servicing client, those funds would flow through to you. The only difference is on that document, it's going to show on those assignments and allonges, it's going to show the trust instead of your current entity. And that's a solution. And you could take them, if you sell the loan, you're simply going to come, instead of executing the document yourself, you're going to need to have the trust do it. And with it's the trust, either the administrator, which is AHP Capital, which we can sign here in our office at AHP Servicing for, or we can take it to US Bank. It just takes longer. So the trust agreement provides that either party can execute necessary documents. So it doesn't represent a delay if you are entering into any contract for sale, if you're entering into a contract for sale of loans, a listing agreement of an REO, you just bring us the contract and we will execute that and get it back to you. So you direct what we do on your behalf. And again, all economic benefits pass through to you. So that's solution. So we've had, we haven't, until today, we really haven't announced that we do this. We've just had people come to us and say, hey, the first one that came to us actually was in the midst of an enforcement action with Pennsylvania, saying I got to do something. We made a deal for them to transfer the loans into the trust. And then since then, we've had a handful of others, and they have the loans are deposited. And usually they're restricting it so far. It's been to the loans that they consider high-risk states like Pennsylvania and Georgia. And so far, that has worked very well. We charge a modest fee for each loan that's deposited into the trust, and then a modest monthly fee. The fee is $200 to put a loan into the trust, and then $10 a month. And then we require that they're serviced by us at HP Servicing. So because we require that they're serviced here. Since our name is on these, we want to maintain some control, even though you have all authority to manage the asset. Now, if you have, so select loans. The other way is if you have a whole portfolio and you thought, we had another group that was crowdfunding, and in their filing with the SEC, they said that they were going to hold all their loans in a trust with a national bank trustee. So they wanted to demonstrate that they were holding these compliantly. They then went out to the different national banks as trustee that were potential trustees, and those banks said, we're not doing it. Either they're not going to do it anymore or they weren't going to do it for this group. Again, because of the reputational challenges that occurred a decade ago, many of the banks have become increasingly concerned, or I shouldn't say concerned, but increasingly strict about who they do business with. And it's not to say that this group was not a good group. I think they were just maybe a newer group, and the banks, it was easier for them to just say no. Now, if you're calling and you're from Goldman Sachs, I imagine they'll do it, but they're not going to do it. Or the experience was it's become more difficult to get a bank signed on to be your trustee. So this group ended up working with us, and we created a whole new series of our trust just for them. And that is also another option. It's a much more costlier option, but if it's a large number of loans, then it can be very very cost effective. And because we already have this trust set up, and you're simply creating a new series compared to setting up a whole new trust, it is cost effective. So in either situation, we're very happy to help and help you hold your mortgages compliantly. So that is something that we encourage you to reach out to us on. Again, if it's a smaller number of loans, there's a per loan fee to deposit plus a monthly, again, $200 plus $10. Or if you want to create a separate series of the trust, that's a customized solution which we can do for you. And then your loans are going to be, US. If your firm was named Blue Bonnet Mortgage, then the loans would all be held in U.S. Bank Trust as National Association as trustee for the American Homeowner Preservation Trust Series Blue Bonnet. And so those are the it would be something that actually has your name in the trust name. So those are that's the solution that we offer. And David Normand is our Director of Business Development. He can help you get set up. So we encourage you to reach out, and we also encourage questions. If there's any questions right now, I'd love to answer them in a group, because if there's a question that someone has, then many times multiple people have them. I see a question right now. Are these limited to residential loan sales or residential notes? No, we can do commercial. We could definitely, and we have held commercial loans in the existing trust. Compliance concerns on a commercial loan would be typically less than a residential loan, so you may not have, well, actually, I don't want to interpret the law incorrectly, Christine. I haven't seen, the level of scrutiny is typically much greater on a residential consumer loan. Yep. I'm not sure, reading through the Pennsylvania actions, were you able to determine if that would also apply to commercial?
It depends on what type of loan it is. We'd have to look case by case to see what type of product it is, as to what type of license would be required.
So that's a good lawyerly answer. It all depends.
It all depends.
Yes, but Wesley, there's no limit to what gets put into the trust. It could be commercial, it could be vacant land, it could be agriculture, it could be residential. Typically, it's done mostly for residential for compliance reasons, but if there's any other reason, it's more than welcome to deposit in the trust in an abundance of prudence. But it is something where we have a and then it's really on your side whether you determine, hey, this benefits me. Based on the enforcement actions, we're confident that this is a significant benefit. If you hold a mortgage on a residential property in Georgia or Pennsylvania and other states, but those are the states where there's, I think, are the high risk states. And I think the risk is pretty much focused on residential, but like Christine said, I please encourage you to see if you have exposure on commercial or any type of other asset, multifamily, and if so, then reach out, and we're more than happy to accommodate you. From Chad, can we buy new loans that are in license requirement states? Can we put into the trust? And if so, should we designate the trust as a buyer? Great question, Chad. Yes, this isn't restricted to loans that you're already held in your portfolio. You can also buy loans, and when you enter the purchase contract, you want to designate that these are being purchased into the trust, and we'll provide you the necessary information for that. But yes, great question, and that is the case. And again, some sellers right now, because they're at risk of getting fined by the state of Georgia, they have been requiring that the loans that they sell are being sold into a compliant entity. So then they wouldn't, in some cases, those sellers won't even allow it to be sold into a non-compliant entity. We need to go into the trust day one. Good question. I appreciate it, Chad. And that may be the questions for the day. So I'm hoping this was helpful to you. We continue these Wednesday webinars. We're trying to kind of highlight different solutions that AHP can offer for loans that you hold, and other kind of ways you can maximize your revenue, maximize your control over your assets, whether it's you know, last week we talked about how you can AHP can work with you on your performing loans that maybe are land contracts, maybe are lease to owns, maybe are have some compliance or document deficiencies. On those, we can solicit your borrowers to refinance, whether it's third party or simply a loan that is sold back into your fund. In either way, you get to go from a non-compliant loan to a compliant loan, or even a land contract. Can be arguably compliant, but it's certainly not very marketable. And you know, most of the buyers that will probably pay the most for that performing asset, if it's a land contract, they typically can't securitize. So your assets become more valuable when they're on a full compliant mortgage file. So we've been doing that for a number of funds lately, and it's been for quite a while actually, and it's been helpful. So we encourage others who find that helpful. It could be one loan, it could be dozens or hundreds. We also offer branch servicing. If you really want to maximize control over the disposition of your assets, we offer to help set up a branch of AHP servicing in your location, and other solutions. So more to come. We're going to continue this for the next few weeks through, I think, the IMN conference is going to interrupt it on the 27th of September. We hope to see you there. Pre-REO, one of our sister companies, is a sponsor, and much of the AHP servicing team will be in Santa Monica for the IMN conference at the end of September. So we hope to see you there. And have another question from Hammond. The servicing is just like any other service, annual interest disclosures, et cetera, et cetera. Yes, you're right, Wesley. The service, you know, well, I'm hoping we're better, but the actual servicing process and services that we offer would be comparable to any other servicer out there, and we'll do all the necessary disclosures. And Christine is make sure, because many of these are have state level differences, she makes sure that all the proper notices are done on every loan we service. All right, I think that is it. So right on time. It's 12:28. So I'll give everyone back a minute or two, and I appreciate everyone attending. If you're interested, please reach out to David. He can get you started. Again, we can do one loan, we can do hundreds of loans, we can do thousands of loans, and help you hold your mortgages in a compliant manner. So thanks everyone. Have a great rest of the week, and we'll see you next week. Thanks again. Thanks, Christine.
No problem. Bye, everyone.
Bye.